One decision, one guilty plea, and just like that, his freedom starts slipping away. In this courtroom, every answer is yes, but the consequences are far from simple.
In person, we have Mr. Allen appearing in person with counsel Joel Feliski. It says we're set for a plea hearing and an initial appearance. Mr. Feliski, please update the court.
Thank you, Your Honor. I was only just recently informed of the new charge, the new case filed against Mr. Allen. So I'm not sure if we're ready to proceed with the initial today. However, we are ready to proceed with the plea. Mr. Allen has agreed to plead in count 1, 25 CF 98, with count 2 being dismissed and read in. The parties are making a joint recommendation for a PSI to be ordered. The state will be capped at the recommendation of the PSI while the defense remains free to argue. I have a completed plea questionnaire form with me. May I approach?
Just wait 1 second. Mr. Vila, the other matter is a felony bail jump allegation. With that new charge, does the offer still exist?
Yes, Your Honor, the offer is still intact, and we can deal with the initial at a later date since Mr. Feliski was unaware previously.
So is this not something that could be contemplated as being a part of this agreement? Do you need time, since Mr. Feliski has never had an opportunity to even review if this existed?
I would defer to the defense of how they want to proceed, but the offer is going to be to dismiss and read in that charge into this global agreement anyway.
So it makes absolutely no sense to waste some time and to set it for another initial. Why don't I just give time? I want Mr. Feliski, since you're just aware of it right now, I am going to print it off unless you have access to it. You have access to it.
Do not believe I have access to it, Your Honor. I don't believe like I said, I wasn't aware. I wasn't appointed to this case.
What I'm going to do is I'm going to print this off for you, Mr. Feliski. I'm going to allow you to read it quickly, and then I am going to have you briefly discuss with Mr. Vila the matter, because I want you to do your job and not have any chance of ineffectiveness, and then discuss with him the potential of having this, as he stated, as a possible dismissed and read in, and then talk to Mr. Allen, and then update me and let me know what we're doing here today.
Certainly, Your Honor.
You can come on up, and it'll be printed right there. We are adjourned briefly. I have a Debbie. Is the Debbie for the Gerald Lindquist matter? I believe it would be related to a victim. Is that correct?
That is correct.
All right. We are not yet there, obviously, and it actually may be slightly delayed, but I just wanted to let you know that so you can be aware and just hang out, okay?
Okay, thank you. Appreciate it.
Thank you. Thank you. I have in front of me a plea questionnaire waiver of rights form. Mr. Allen, do you recognize the document?
Yes, ma'am.
Did your attorney thoroughly go over this document with you?
Yes.
And he went over it word for word?
Word for word, yes.
And you understand everything completely on this document?
Yes, ma'am.
If by chance you didn't understand something thoroughly, did you ask him to explain it?
Yes.
And he did so?
Yes, ma'am.
So you are telling the court you fully understand everything?
Yes, ma'am.
Is that your signature on the second page?
Yes, it is.
So even though prior to this hearing, the new case 25 CF 178 was not included in the offer and was not included in the offer and the acceptance, nor was it added to the plea questionnaire waiver of rights form. You understand now that it is, and again, you waive any allegations or claims as it relates to Mr. Feliski and his representation with you on that new charge?
Yes, ma'am.
So you're 39 years old, you have 12 years of schooling, you can read, write, you understand the English language, is that correct?
Yes, ma'am.
You are pleading guilty to possession with intent, methamphetamine greater than 10 grams, but less than 50 grams, is that correct?
Yes, ma'am.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
Did your attorney go over with you the maximum possible penalties you face?
Yes, ma'am.
No mental illnesses or disorders, no alcohol, medications, or drugs within the last 24 hours?
No, ma'am.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on this plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
I am going to briefly go over those rights with you again, simply because this is a serious charge of a Class D felony, and I want to ensure that you fully understand those rights, okay?
Yes, ma'am.
Do you understand that you would have the right to a trial? You would have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
Did you review the criminal complaint with your attorney?
Yes, ma'am.
And that would be the original charging document and all of the facts that are alleged in that?
Yes.
For the most part, are those facts accurate?
Yes.
The state would have to prove here today that count one, possession with intent to deliver methamphetamine greater than 10 grams but less than 50 grams, that on or around July 10, 2025, you possessed a substance with the intent to deliver a controlled substance, to wit, methamphetamine, again, in an amount of more than 10 grams but less than 50 grams. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $100,000 or imprisonment of not more than 25 years or both?
Yes.
You understand that?
Yes.
And again, first there's an offer here that is presented by the state and you have accepted, where the court will order a pre-sentence investigation report. The state would be capped at that recommendation in the PSI, and the defense would be free to argue. Do you understand what a pre-sentence investigation report is?
Yes.
Do you understand it will contain a whole lot of information about you and your life, and provide a recommendation as to sentencing from the Department of Corrections standpoint?
Yes.
Do you understand I'm not bound to follow that recommendation?
Yes.
I'm not bound to follow the recommendation of the state,
Yes.
and I'm not bound to follow the recommendation of the defense. Do you understand that?
Yes, ma'am.
Do you understand that I am free in my own discretion to sentence you to what I believe is an appropriate sentence based upon all of the facts in this case and all of the information that is provided to me about you? Do you understand that?
Yes, ma'am.
And it could be the maximum possible penalty. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Now, with regards to that criminal complaint, you did review it thoroughly, and you are admitting here today that for the most part, those facts are accurate, correct?
Yes.
And your attorney thoroughly went over those facts with you,
Yes.
and you do understand them completely?
Yes.
Are you pleading guilty today of possession with intent to deliver methamphetamine because you are guilty of that charge?
Yes.
And it is and was an amount greater than 10 grams but less than 50 grams?
Yes.
Mr. Feliski, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you, Mr. Allen, for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing here today
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
And he's looked at all of the discovery in 25 CF 98 and discussed it with you?
Yes.
Has he discussed with you the potential for any defenses you could have?
Yes.
Has he discussed with you any potential of a lack of defenses with you?
Yes.
Has he discussed with you that it is yours and your decision alone to make whether or not you proceed to a jury trial?
Yes.
Are you satisfied with his services?
I am. Yes.
Any questions for the court or your attorney before I proceed?
No, ma'am.
Now, with regards to 25 CF 178, you understand that charge of a felony bail jumping allegation
Yes.
on or around December 4th, 2025. It's alleging that as being charged with this previous Burnett County case, 25 CF 98, and you were released from custody, you intentionally failed to comply with the terms of your bond by failing to pass a drug screening test and by using an illegal drug or substance. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 6 years or both?
Yes.
And do you understand that you would have the right to have a preliminary hearing?
Yes.
And you understand what that hearing is?
Yes.
Did your attorney have the ability to discuss that with you here today?
Yes.
And are you telling the court you wish to waive the right to that preliminary hearing?
Yes.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, would be able to call witnesses on your behalf. He would be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses, but you're giving up those rights today?
Yes.
Do you understand that if the state does not meet its burden as to that felony, I could amend it to a misdemeanor or I could dismiss it altogether, but you're giving up that right today?
Yes.
Do you understand that as a result of waiving the right to a preliminary hearing, you would have been given an opportunity to have a trial on this matter?
Yes.
Do you understand that once you give up the right to a preliminary hearing, it is forever and you cannot get it back?
Yes.
Has anyone made any threats or promises to you other than an offer that you've accepted to dismiss and read in this charge? Have they made any threats or promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
I will find that you're competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and I do bind that matter over. Information for 25 CF 178.
Thank you, Your Honor. I'm going through and filing the information now. It mirrors that criminal complaint.
He understands charge and maximum penalty and enters a not guilty plea.
Yes, Your Honor.
All of that is done. Not guilty plea is entered on your behalf. Again, you would have had the ability to go to trial. You still can if you tell me you wish to do that, and you would have the right to have a speedy trial on that matter if you desire. Do you understand that?
Yes.
Okay, the not guilty is entered on your behalf. Now, as it relates to the other matter, do you have any questions for the court with your plea or for your attorney before I proceed and ask what your plea is?
No, ma'am.
All right, then count one, possession with intent to deliver methamphetamine greater than 10 but less than 50 grams in 25 CF 98, a class D felony, maximum penalty, $100,000 fine, or 25 years of incarceration, or both. How do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of that count. The other matters will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. The court will order a pre-sentence investigation report, long form. Agent does not need to appear, but should be readily available by telephone in case questions arise. At this time, the court is going to revoke your bond. This is a serious felony. I'm going to set the matter for a sentencing hearing no sooner than 60 days out to give DOC an opportunity to prepare the report. I am pretty open the week of March 23rd. Mr. Feliski, any preference on a day or morning or afternoon?
Your Honor, I have availability all that day, all that week, apart from the 26th. I have a trial in Washburn.
You're arguing, Mr. Vila?
Yes, Your Honor.
I'm just trying to figure how long we may potentially need. 45 minutes, starting at 1.
I believe that's appropriate, Your Honor.
On the 24th. So March 24th, 1 o'clock to 1:45, we will schedule the sentencing in this case. Anything further from the state?
I don't believe so, Your Honor.
Mr. Flisky?
Nothing further. Thank you.
All right, thank you. We will see you on March